Good morning. The Florida Commission on Ethics is now in session. We will begin our public session. Ms. Westford, can you please call the roll?
Commissioner Duran, Commissioner Kerner,
Here.
Commissioner Oglesby,
Here.
Commissioner Phillipson,
Here.
Commissioner Rogers,
Here.
Commissioner Stewart, Commissioner Stumphauser,
Here.
Commissioner Webb.
Here.
We have a quorum present.
Thank you. If everyone can please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Some brief housekeeping announcements. The First DCA graciously lets us use these facilities, and we appreciate being able to utilize this courthouse space. At this time, if everyone can please silence your cell phones. This meeting is being live streamed, so I ask anyone addressing the commission to please make sure to speak up and speak into the long microphone at the podium, so you can be heard and so our broadcast audio and recording equipment can pick up your comments. To my fellow commissioners, please speak up into the microphones on the dais so your comments and debate can be heard. Members, I ask that you be as brief and concise as possible in your questions and comments with the number of items on the agenda for consideration today. Pursuant to section 286.0114 of the Florida statutes, members of the public can have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you wish to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up. I'll now entertain a motion for approval of our minutes from the public session on July 24th, 2026.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
All those opposed? Ayes have it. The minutes are approved. At this time, I'd like to welcome a new member. I'd like to welcome Commissioner Ryan Stumphauser to the commission. Commissioner Stumphauser recently was appointed to the commission by Speaker Perez. Commissioner Stumphauser, would you like to make any comments?
No, just glad to be part of the commission. Glad to be here and do the work. Thank you.
Thank you. Appreciate it. We'll move to item number 4 on our agenda, consideration of dismissal of certain allegations in a complaint number 22-079, N. Ray Randall Fine. This first item on the agenda is the consideration of dismissal of certain allegations in complaint number 22-079, N. Ray Randall Fine. The commission previously found probable cause in this complaint and subsequently referred it to the Division of Administrative Hearings for a public hearing to determine if the respondent violated the Code of Ethics. Our staff has prepared a draft for our consideration to dismiss certain allegations in the complaint. You were provided this in advance of the meeting. Will the parties or their counsel please identify themselves for the record?
Richard Coates for.
Mr. Coates, can you please come to the dais?
Yes, sir. Right, push any buttons.
No, you just speak in this live mic.
Richard Coates for Randall Fine.
Hey, Mr. Coates. And for the commission?
Gray Schaefer,
Thank you,
Commission
Jeff.
Attorney.
I'll recognize Grace Schaefer to explain the draft order to the commissioners, and then we will entertain questions from the commissioners. Mr. Schaefer, you may proceed.
Thank you, Chair. This draft order before you recommends you dismiss certain allegations in complaint 2279 based on our new standard for conducting ethics investigations. Before I give you all the background on the complaint, let me give you some context about these recent changes in the ethics laws. As you might know, about 2 years ago, during the 2024 legislative session, a bill was passed making a series of procedural changes to the Code of Ethics. Now, one of those changes was a change to our complaint statute, Section 112.324. The legislature included language indicating the commission could only investigate those allegations in a complaint if it was clear from the complaint that the allegation was based on personal knowledge or information other than hearsay. Now, that particular statutory change did not give a certain date or a time frame as to when that change in our investigative powers would start to apply. So for the past 2 years, at several points, the commission has had to consider the question of how this change would affect investigations of complaints that were already ordered before this statute was amended. In other words, whether or not this should be retroactively applicable to complaints that were already in our pipeline at the time the statute was changed. And we advised you that this change should be applied retroactively for 2 reasons. First, the legislature could have tied this particular change to a specific date, as it did with some other procedural changes that it made to the complaint laws around that same time. But the legislature chose not to do so, which implies then that this change was to affect all active cases of the commission, even those that had already been ordered to be investigated. The second reason why we think this is retroactively applicable is that the appellate courts have found that changes affecting an agency's investigative powers should be retroactively applied unless the legislature specifically stated they're just to take effect moving forward. And again, that wasn't made regarding this particular change here. The commission, when this has come up, has taken staff's advice on this issue and agreed that this new investigative standard requiring an allegation to be based on personal knowledge or information other than hearsay to be investigated should be applied even to cases where an investigation has already commenced. So you voted in the past to exercise section 112.324 subsection 12 to dismiss these kind of complaints. Now let me explain what that provision is. 112.324 subsection 12 says the commission can dismiss an ethics complaint or an allegation at any stage of disposition if it finds the public's interest will not be best served by proceeding further. So in the past, when this type of issue has come up regarding complaints that were in the process before the statute changed, but which don't meet our new investigative standard requiring personal knowledge or information other than hearsay, the commission has directed staff to prepare orders dismissing those allegations using section 112.324 subsection 12 on the basis that it won't serve the public's interest to continue because the complaint no longer meets our new investigative standard. So that's all the legal background on this. Now let's turn to complaint 2279 itself. I think it's important to note this complaint was filed before the investigative standard changed in 2024, requiring an allegation based on personal knowledge or information other than hearsay. The respondent here is a former member of the Florida House. He's a current member of the U.S. Congress, and the allegations of the complaint all pertain to matters that occurred while he was still serving in the Florida House. Now, to work you through the procedural history of this case, I know the chair gave you a brief look at that. There were 6 allegations raised in the complaint. Back in July of 2022, staff recommended dismissing the entire complaint, all 6 allegations, as legally sufficient without even conducting an investigation on the basis that, depending on which allegation you're talking about, they either only concern private capacity conduct or they didn't identify the personal benefit needed to trigger the misuse of public position statute or the disproportionate benefit amendment in the state constitution, which we felt were the only 2 prohibitions that were applicable. Now, despite the staff's recommendation of legal insufficiency, the commission at that time rejected the recommendation and ordered that all 6 allegations be investigated under the misuse statute and the constitutional prohibition. So the matter is fully investigated. The ROI forward is included in your meeting materials, and that ROI was then given to our advocate to make a probable cause recommendation. The ADREC she submitted is also included in your materials. She looked at the allegations and the content of the investigative report and again recommended no probable cause on the entire matter. Despite the advocate's recommendation, the commission voted to depart from that and found probable cause to send all of the allegations over to DOA on the basis that an evidentiary hearing was needed. Now, importantly, all of what I've just described that happened with this complaint happened before the investigative standard changed in 2024. They all preceded the change in the law that says that the allegations have to be based on personal knowledge or information other than hearsay. Now, as the chair described, the matter was then sent to DOA, but was then sent back to the commission in 2024 in August. At that point, the respondent, through his counsel, requested the commission reconsider if probable cause is really present. Now, your staff, as well as the commission advocate, took no position on the question of whether or not probable cause should be reconsidered. And the commission at that time heard argument from the respondent's counsel, but still decided to continue with probable cause, and so it denied the motion to reconsider. And that's where this complaint is at today. There's been several continuances on it since then, but right now as it sits, it's still under the commission's jurisdiction, but it's poised to be sent back over to DOA for a full evidentiary hearing on all 6 allegations. Now let's circle back to what I was saying earlier about that investigative standard. Before the matter was sent back to DOA, staff flagged the issue that 3 of the 6 allegations don't appear to meet our new investigative standard. They don't appear to be based on the complainant's personal knowledge or information other than hearsay. And if the complaint was filed today, we would not be recommending that you proceed on these 3 allegations. So staff now is bringing that specific question before you. And this is the first time the commission as a body has heard it, which is whether or not these certain allegations in the complaint should be dismissed on the basis that they don't appear to be based on personal knowledge or information other than hearsay, which is this new standard that needs to be retroactively applied to the complaint. The draft order in front of you describes the 3 allegations where we have concerns. That's in paragraph 5 of the draft order. First, there's the claim that the respondent encouraged a city council member to write a social media post that was critical of the complainant, who was a school board member at the time. But the complaint just doesn't explain how the complainant knew the respondent made such encouragement. Second, there's a claim the respondent told a city council member not to take advice from the city attorney on a records issue and to fire the city attorney. The complaint says it's basing that on statements the complainant heard from others and statements that she read in a newspaper. All that would be hearsay. Third, there's a claim the respondent hired a private investigator to surveil the complainant, and then, based on the investigator's findings, posted those findings on a particular website. And the claim is that those findings were false. The complaint says the claim that the respondent hired the investigator and was responsible for posting those findings is based on statements she heard from another, and that again would be hearsay. So the order in front of you, which is in line with what you've done with other complaints that were in the pipeline but don't meet our new investigative standard, recommends dismissing these 3 allegations using section 112.324 subsection 12 on the basis that it wouldn't serve the public's interest to proceed further on these 3 allegations because they don't appear to be based on personal knowledge or information other than hearsay. I will say there are still 3 remaining allegations that do appear to meet our investigative standard. They're described in paragraph 6 of the order in front of you. Each of these remaining 3 allegations appear to be based on personal knowledge or information other than hearsay. So what this draft order in front of you would do would be to dismiss the 3 claims that don't meet our new investigative standard, but just refer on to DOA the remaining 3 claims that do. Again, this takes the approach on these types of cases that you all have used in the past. It does not dismiss the complaint altogether. It just limits the allegations on which it will proceed. I submit it to you now for your approval, and I'm happy to answer your questions.
Thank you, Mr. Schaefer. Do any of the commissioners have any questions for Mr. Schaefer? Mr. Schaefer, I have one question just for clarification for the record. Paragraph 6 of the proposed order, what the commission staff is saying is those may satisfy statements other than hearsay, but not necessarily whether those would satisfy probable cause determination. Now,
That is correct. Probable cause has technically already been found on all 6 allegations. What we're doing here is just saying that 3 of the 6 allegations on which probable cause is found do not meet the investigative standard. So this is not touching probable cause.
Okay. And the staff's initial recommendation when this first came up, when this complaint was first filed, was legal insufficiency. And then after Ms. Hadley's recommendation was finding no probable cause at that time.
That's correct.
Okay. Any other questions from the commissioners? Mr. Coates, you're recognized for 10 minutes.
I'll be very brief. Thank you, Chairman. This matter between these parties has been going on now for 10 years. This is a political tempest in a teapot, and these people don't like each other. There's probably at least 15 complaints that I've worked on between this agency and the Elections Commission between these 3 parties, Mr. Burns, Ms. Jenkins, and Congressman Fine. Staff had it right the first time when they said that this matter was legally insufficient, and the advocate's recommendation when looked at it from a dispassionate view that there was no probable cause was also accurate at this particular point in time. We would hope that at some point, 324 would apply to all 6 charges in this matter, as I don't think there's anything in the public interest to pursue these any further. You're just furthering a political fistfight.
Thank you, Mr. Coates. Do the commissioners have any questions for Mr. Coates? Then we'll move to discussion and debate. Anyone wishing to have any further discussion on the proposed order? Based on our track record when evaluating the new statute and application, we've consistently done what is being recommended today. If it doesn't meet information other than hearsay, we've gone back and dismissed those actions. This one, looking at paragraph 6, based on the review of what we've been looking at least in the year Commissioner Rogers and I've been on the commission, a number of these I don't think would have even gotten to a probable cause. And whether at this time with the resources and our limited government resources, whether we dismiss those 3 allegations and take no further action on the remaining 3 versus it going back to DOA and going back to the process. Would anybody like to discuss that further?
Yes, sir, Mr. Chairman. So we know that the advocate made the recommendation to not move forward. What was the board's reasoning at the time to move forward? Are you?
I was not on the commission at that time. Mr. Zolkowski, do you remember, were you with the commission at that time? The chair recognizes General Counsel Zolkowski.
Thank you, Commissioner, and through the chair. So the question, as I understand it, is what was the board's reason at the time for proceeding on the matter with probable cause?
Yes, sir.
There was a discussion for sure, but the motion itself never had, as you know, from being on the board for a little while, the motion never has a reason. So it would be probably improper for me to say exactly what the reason was. Each commissioner was bringing something different to that discussion. If you went back and listened to the audio, everybody had a different viewpoint on it, getting to some sort of outcome on it. I don't recall exactly what the vote was, what the numbers on it were, but I don't know that there was any one particular reason, but in their wisdom, at the end of the day, when posed with the question, probable cause, no probable cause, they decided to vote for probable cause.
Understood. Thank you.
My thinking would be is we will, I don't want to create a precedent reconsidering prior to commission's decisions, but looking at this more in the sense of this is a different complaint now that has been narrowed down to these 3 allegations in paragraph 6 of, with it now being in a different posture and a different complaint than what was initially presented to the commission, whether the government's resources are better spent on other matters and taking no further action on those 3. What's currently before us doesn't include that. What it does include is the allegations in paragraph 5 not meeting our standard of information other than hearsay. Information, knowledge, personal knowledge, and information other than hearsay. So is there any further discussion, or I'll entertain a motion?
Mr. Chair, before you entertain motion, I just
Yes.
need to put something on the record
Yes.
that I'm going to be abstaining from this matter, any participation in the decision based on a discussion with our general counsel under section 286.012 to avoid the appearance of any unfairness and assure the view of fairness of this proceeding based on some other professional affiliations that I have.
Thank you, Commissioner Webb. Any further discussion or any motion from the commission?
Chair, I'll make a motion that we move forward with removing the 3 charges that we've just discussed.
There's a motion to approve the draft order dismissing certain allegations in the complaint as written and presented to the commission prior to this meeting. Is there a second?
Second.
There's a second. All those in favor?
Aye.
All those opposed? The ayes have it. The draft order dismissing certain allegations in the complaint is adopted as written. Thank you, Mr. Coates. Thank you, Mr. Schaefer. Moving on, we have consideration of order on request for extension regarding N-Ray Duncan DeMarsh, N-Ray Jason English, and N-Ray Caroline Shorter. The law gives the chair the authority to grant financial disclosure files extensions of time up to 45 days for the individual to file their disclosure form. Item 5 on the agenda consists of 3 requests for an extension of longer than 45 days to file their annual financial disclosure form. Are there any members who have questions or who would like to have staff present the draft orders? Are there any members who need to make any disclosures at this time? Seeing none, I'll entertain a motion to adopt the orders as written.
So moved.
Second.
All those in favor?
Aye.
All those opposed? Ayes have it. The orders as drafted are adopted. Item number 6, consideration of final orders on financial disclosure fines where there has been no timely appeal and no payment. We have before us consideration of default final orders where a reporting individual failed to make a timely appeal or failed to pay an automatic fine assessed for failure to timely file their annual financial disclosure form. With your approval, a default order will be entered for each of the individuals on the list. Those in a position receiving public funds will be referred for salary withholding, and the others will be transmitted to the collection agency contracted by the Department of Financial Services for collection. Are there any disclosures or questions from the members?
Yes, Mr. Chair.
Commissioner Webb.
Disclosure, again, under section 286.012, after discussion with our general counsel, I'm going to abstain from any action or vote on 4 of the individuals listed to assure the appearance of a fair proceeding based on other professional affiliations that do not necessarily have a financial interest in this. And those would be the names Green on page 5, Hansley on page 6, Brown page 14, and Zalewski on page 18. So I'll abstain from any decision on this.
Thank you, Commissioner Webb. I as well will be abstaining from one of the default final orders. I must disclose a voting conflict on this agenda item after discussing this matter with our general counsel. I've confirmed that one of the proposed names to receive a default final order here poses a voting conflict for me. I have a professional relationship with Mr. Bruck, whose name appears on page 12 of the materials. I will pass the gavel to the vice chair for a separate vote on that individual, and I will abstain. I'll be voting on the other individuals under review in this matter, and I've already filled out a voting conflict memorandum. So we will take up let's take up everyone other than Mr. Bruck on page 12. Is there a motion? I was going to do Bruck. After that one.
You won't be able to vote on that.
Right.
So would just be everybody but Brock, Green, Brown, Mitchell, Zalewski. And then you'll do those 4 separately.
Will we have enough? 1, 2, 3, 4. We'll have enough. Okay. All right. So we'll be doing on this one, we'll be doing everyone other than Green, Hansley, Brown, Zalewski, and Bruck. Yes. And so I'll entertain a motion to adopt the proposed order presented in advance
Moved.
on the remaining individuals listed.
Sorry, Mr. Chair. So moved.
Second.
All those in favor?
Aye.
All those opposed? Ayes have it. I'm going to pass the gavel to the vice chair with regards to Mr. Green, Hansley, Brown, Zalewski, and Bruck.
All right, thank you, Mr. Chair. All right, I will entertain a motion to adopt the draft order as it pertains to the names just read by the chair.
So moved.
Do we have a second?
Second.
All right, all those in favor?
Aye.
Any opposed? All right, it carries.
All right. Moving on to item 7, consideration of rulemaking. We have one rule hearing on our agenda today. The purpose of a public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed rule.
One moment.
Oh. It's always dangerous if he's running to
We're gonna have
the.
to move to-
I think we got a weird Venn diagram going.
We-
Yeah.
yeah,
I think
need to
we
do this.
were, just to make sure what we just voted on, I understood it to be the 4 that Commissioner Webb was abstaining from. We still haven't voted on Bruck.
We,
No, they
we,
include-
we included Bruck in that one.
Then you don't have a quorum for that because.
That's
both-
what I was wondering.
Yeah, no,
Yeah.
there needs to be 3 total votes here.
Okay.
Yeah.
Understood.
So
Let's.
what I would recommend, Mr. Chair, is
Yeah.
that you run a vote on the 4 that Commissioner Webb is abstaining from.
And then we'll run
And
the
then
Bruck vote
Commission-
separate.
Commissioner Oglesby will run a vote on Bruck.
Okay. That was my original plan. All right. Let's do this one more time. I'll entertain a motion on adoption of the order as it relates to Green, Hansi, Brown, and Zalewski under item 6.
So moved.
All those, is there a second?
Second.
All those in favor, say aye.
Aye.
All those opposed? Ayes have it. I'll move the gavel over to the vice chair for Mr. Brock.
All right, now we will entertain a motion to adopt the draft order as it pertains to Mr. Brock.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Any opposed? All right, it carries. Thank you.
Maybe I should have gone my gut on that one. Thought I had it. Move to item 7. We have one rule hearing on our agenda today. The purpose of a public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed rule or proposed changes to an existing rule. Following the public hearing, the commission will decide whether to make any changes in response to public comments or written materials received, or whether to accept the rule as noticed. The commission may withdraw a rule in whole or in part, or may make such changes as are supported by the record of the public hearing or any written materials we have received. The commission also may make technical changes which do not affect the substance of the rule. I'll ask Amelia, who prepared the draft item, to explain the rule changes and put us in a proper posture, and then we'll proceed with the public hearing, deliberation, and vote.
Thank you, Mr. Chair. So Commissioners, this particular series of rule amendments all pertain to Rule 34-8 of the Florida Administrative Code, which among other things sets out and incorporates by reference the instructions for the Commission's various financial disclosure forms. Now, as you know, there are 2 sets of forms that the Commission issues, the Form 6 and the Form 1. For each of those forms, there's also the Form 6X and the 1X, which are the amendment forms, and the Form 6F and the 1F, which are the final forms. Now, there are just 2 minor changes that we are proposing today. These changes were summarized in the memo provided for you in your meeting materials, but I'd like to highlight them for you very briefly. First, simply, we need to update the calendar years on the instructions to reflect the 2026 calendar year, which is pretty straightforward. This change needs to be made on the instructions to the Form 6 and the Form 1, and the instructions for the Form 6 and Form 6F and Form 1F need to reflect the 2027 calendar year, as those forms will need to be filed next year when a public officer or employee leaves his or her position. Second, we also simply need to update and correct some of the statutory and constitutional citations in the instructions, as some of them have changed locations in the past few years. So if you have questions, please let me know and I'd be glad to address them. I'll note that all these changes have been duly noticed in the Florida Administrative Register. We've also provided them to JAPSI, and they stated that they had no objections. So if you decide to approve the changes today, the only steps remaining will be to file a notice of no change with JAPSI and then submit the amendments for adoption with the Department of State. Now with that, I submit these changes to you now, and I'm happy to answer any of your questions.
Are there any questions for Ms. Noe on the commissioners? Thank you. Ms. Fulford, is there anyone here, has anyone identified a card that wants to speak? And is there anyone in the audience who wishes to be heard on this rule? Seeing none. We'll move to deliberation and discussion by the commission members. Does anyone need any further explanation of the proposed rule? Then I will entertain a motion for a vote to file the proposed rule with the Department of State for adoption.
So moved.
Second.
All those in favor?
Aye.
Aye.
All those opposed? Ayes have it. The motion is adopted and it is to proceed with filing the rule with the Department of State. Next, we move to item 8, consideration of our 2027 legislative recommendations. At our prior meeting, we identified as a commission at least 2 items that we wanted to emphasize and said that we would table it to take up at this meeting for finalization of our legislative recommendations. You have a memo in your materials outlining a number of possible recommendations to discuss. We're not limited to the discussion of the items on the list. Before we begin, are there any members of the public who wish to speak on this matter? Seeing none, I'll recognize Executive Director Stillman to provide some additional detail regarding the items in the memo.
Thank you, Mr. Chair. As you mentioned, the last meeting, you all decided that as we head towards the 2027 session, that you wanted to be more targeted with your recommendations instead of having a longer list. A couple of the items that you seem to be interested in moving forward with was the whistleblower protections for ethics complainants. You'll recall that we got pretty close last year with our sponsors on this bill, but ultimately the whistleblower protections died in the House and the Senate. It's something that you have discussed and recommended for a number of years, especially in light of personal knowledge and information other than hearsay. The issue seems ripe to permit public employees to have some sort of protection if they file an ethics complaint. And so you have indicated a desire to move forward on that, although no formal vote has been taken. I can answer questions about that one if you wish. The other recommendation that you seemed very interested in was to pursue a records exemption for commission staff and members. This is probably a heavy lift, given the sensitivity of transparency and how much we value that in the work that we do and how much citizens value that. But as we discussed at the last meeting, the types of decisions that you all make have a significant impact on complainants and citizens and officials alike. Members of your staff travel to different places for investigations, and members of staff who are at the commission often speak with very emotional individuals regarding matters that are important to them that they think should be pending before the commission, or matters that have been pending before the commission. And we have received threats as individuals, and we've increased security at our office in the last few years. Commissioner Stewart at the last meeting noted that the thought that as we present this to the legislature, if members of the legislature, if it's more favorable to them to only seek the exemption for staff, that she was in favor of doing something like that. The way we left it is that, you know, maybe you make the full recommendation for both, and then we leave it to the wisdom of the legislature or the sponsoring members of the legislature to decide how exactly they want to lay that out. Another item at the end of that discussion that Steve talked about in detail with you is the Form 10 change. We had legislation on this last year. It's a very simple change in the law to clarify the filing location of the Form 10, which is an annual gift form that discloses honorary and event-related expenses and gifts from governmental entities having a governmental purpose. The way the law is written is a relic from when we didn't have electronic disclosure. And so the Form 10 was filed with the person's paper Form 1 when they filed it either with the commission or with the supervisor of elections, or for Form 6 filers, they also filed that with the commission. The language still says file it with your 1 or the 6, but the Form 10 is not currently an electronic form. It's a paper form. So there's no way to really file it with your 1 or 6. We can do a simple striking of a few words in the law to clarify that all of these get filed with the commission. It's something that's your staff believes it's important to do because forms are adopted as rules. We cannot change the instructions on the form of where to file unless we have a law change. So we would hope that we could present that as a recommendation from you. The other items, the one-time fine waivers for financial disclosure fines, you did not seem interested in proceeding with. There are also a number of technical items for consistency that we have on your list, making appellate deadlines such that if somebody files a financial disclosure appeal and they mail it, that we can go by the postmark date instead of received date, given the postal service. Sometimes that can make a difference as to whether somebody's appeal is timely or not. Clarifying the law so that individuals appointed to fill an elected office, that it is clear that they are indeed required to file Form 6. That is what they are advised to do by the commission now, but we would love for that to be clarified. And also to make the ethics training requirements consistent for when individuals are appointed to fill a vacant seat for an elected or municipal office, that they have to do the training. That language already exists in the law, but only as it relates to, I believe it's CRAs and special districts. So it would be great to have that. We also had some observations regarding the repayment provision and the recent change to the law regarding foreign terrorist groups. So we'd like to have conversations about the possibilities that the legislature may want to make that law consistent in terms of who gets repaid with that penalty that you all would be recommending. And then also with regard to withholding, salary withholding for public officials and public employees who have outstanding financial disclosure fines. We recently determined that it does not appear that you have the authority to direct such withholding from the salary of university employees, because public universities are not any of the entities enumerated in statute. So we could ask the legislature to add them in to make sure that we can utilize that tool that's really helpful to us. And so with that, I'm willing to answer any of your questions and would ask that, you sort of come to a determination today of what your recommendations might be, so that Steve and I, as your official legislative lobbyist, can get running with those ideas and socializing them, even though it is an election year. We can still start reaching out in terms of what you would like to do. And also goes without saying, but I will say it again, any member of this commission who has relationships with members of the legislature, you will be vital to our success with the legislature. Introductions you can make if you want to designate a member or members. Ultimately, you wouldn't have to do that today, who can work closely and alongside Steve and I. That's always helpful and much more meaningful to members of the legislature when we seek to move forward with your recommendations.
Any commissioners wishing to have further discussion? I know at our last meeting, Commissioner Stewart and Commissioner Duran, who couldn't be with us today, I mentioned narrowing it to a smaller group of recommendations this year versus a larger list that we did last year. Commissioner Duran gave some insights as a former member of the House, and Commissioner Stewart as someone who worked in the Department of Education. Is there any commissioners that would like to discuss either the whistleblower protection, the public records exemption, Form 10, or any other matter on the list?
Yeah, Mr.
Commissioner
Chair?
Rogers?
I see them in almost like three buckets, I guess, as proposed. I think the whistleblower protection and the public records exemption are kind of, I see that as like new and actually kind of worthy of considering. There's got to be some talk and consideration on it. I think the Form 10 and then some of the 2026 not filed, those all seem like technical housekeeping to me. So I would recommend, however we do, we kind of put that Form 10 and those other technical housekeeping items just as almost there's just very little controversy in those, I see. I did want to discuss the salary withholding for the universities and then the consideration of I don't know if it was foreign countries of concern or terrorist groups. I'm not seeing anything on that. Is this just a first heard from, or maybe not first heard, but do we have any documentation on that, or is that more for just consideration? That's probably a question for our executive
Ms. Stewart?
director.
Yes, thank you. What we have from the last meeting, we talked about it, and the lawyers, your legal staff realized this, that there is a new provision of law with areas of concern where we have jurisdiction with regard to that law, and the penalty speaks to repayment, and it's unclear in the statute as to who they would be repaying. And so it would be helpful if that were clarified to demonstrate that perhaps that is a penalty of repayment of that amount, maybe to the state general fund or whatever that may be, but some clarification might be helpful in terms of when you.
Mr. Chair.
Yes.
This is for the terrorist group designation repayment, like where that money would go. Okay, so it's kind of like a technical cleanup, I guess. Like,
It would be, it wouldn't substantively change the law, it would just clarify where that penalty would.
and do we have a recommendation on where that repayment would go to? General Rare?
Presumably, the recommendation that we would make if they asked us is to the state or to some entity within the state.
Yeah, through the chair, the concern is that you would have public officers and public employees remitting money to a terrorist organization or a foreign country of concern or some other associated group. That's probably not the intent of the law, but where it says repay, it lends itself to some confusion.
Yeah.
Commissioner Rogers and
Yeah, Mr. Chair, I would say I'm in favor of the Form 10, which is item 3 here, that Form 10, the previously not filed ones going in. I would put this forward as like things for consideration. 1, the whistleblower, 2, the public records, and I would leave us in there. Again, I already have one through some other affiliation, but I think the commission, we do a lot of controversial stuff that people may see, and I'll leave it at that. And then I would put the rest of them under kind of like almost technical considerations. I think that packages it easiest for the legislature, in my opinion.
So with the public records exemption, I know when I went before the ethics committee last year for our legislative recommendations, that was something that stuck out to me. Concerned our staff is on the front line of a lot of these issues. Our investigators are going into various parts of Florida, and these investigations are not public, and they are going into rooms where sometimes their presence is revealed just from someone being in the building, and they can be a very tightly, some tight quarters and have issues of security because of the penalties that come with violations of the ethics code. And then the calls that our staff takes, we've hardened the building and hardened their protection, but I think this added layer will encourage public service, protect our staff, protect our investigators. And so I think the public records exemption is an important one. I believe we are an open record state. I've litigated 119 issues most of my career on both sides of this issue, and we are a state that favors the sunshine, but we also favor protecting our public servants, and that's what our staff is. And so I think the public records exemption is important for the safety and continuity of our agency. I'll entertain if there's any further discussion, I'll entertain a motion adopting as the legislative proposals for staff to proceed on the whistleblower protection and the public records exemption as the 2 primary legislative acts, and that the technical changes can be raised in discussions with the legislature, but the focal point as recommendations from this commission are the whistleblower protection and the public records exemption. Is there a motion?
No.
Or I
I'll
move, second. I move that. It'll be second. All those in favor?
Aye.
All those opposed? Ayes have it. And so our legislative recommendations for this coming year are the whistleblower protection and the public records exemption in item 8. And as well, the staff to raise the technical corrections that are listed in item 8 as a secondary, but our focus will be the whistleblower protection and public records exemption as the commission's emphasis this year. Thank you for the discussion. Thank you, Ms. Stillman, for all the work of analyzing that, as well as our legal team of going through all the technical changes and finding the areas that we can improve the forms and improve the process. Next is item 9, consideration request for additional advocate staffing for fiscal year 2026-2027. Item 9 concerns a request for additional advocate staffing for 2026-2027. Before I recognize our executive director, are there any members who need to make a disclosure?
Yes, Mr. Chair.
Commissioner Webb, you're recognized.
I'm going to disclose a voting conflict on this agenda item after discussing the matter with our general counsel. I confirm that the matter would pose a voting conflict for me because of a client relationship of my law firm, and therefore I will be abstaining from any vote on the matter and will be filing a voting conflict memorandum. Thank you, Mr. Chair.
Thank you, Commissioner Webb. The chair recognizes Executive Director Stillman to present the advocate staffing.
Thank you, Mr. Chair. You might recall at the last meeting, you approved the expenditure for the contract with the Office of the Attorney General's $473,540. It covers 2 commission advocates and 1 legal assistant paralegal. Not long after that meeting, I received a call and found out that the Office of Attorney General's budget request requesting the reclassification of some positions to have 2 more positions within the ethics practice group, an attorney and a legal assistant too, had been approved. That would put a total of 3 attorneys and 2 support staff within the Office of Attorney General to work exclusively on the ethics contract and handling ethics cases that you see before us. Because it is done through a contract with the commission, they have approval for the position, but the commission doesn't currently have in its operating budget the funds to cover the amount that they would need, should you choose to want to enter into an addendum to add these positions. The legislative budget request of the Office of Attorney General is in your materials behind the memo that I provided to you. I want to emphasize that one of the priorities of Senate Bill 7014 was to make the ethics complaint proceedings more efficient. It placed statutory timeframes for certain parts of our process. And one of the new requirements significantly changed the timeframes as they apply to the advocates and filing the advocates' recommendations that are filed in each case following the release of the report of investigation and the complaint file over to their office. It used to be that within each meeting set of internal deadlines, when a case is heard is dependent on when the report of investigation is issued. There was also a deadline for advocates' recommendations. The advocates could file their recommendations at any point up to the date of the advocate recommendation deadline. And that deadline was set because we had to provide sufficient time for respondents to reply to the advocate's recommendation and get that in the meeting materials for you at the meeting where the complaint was scheduled to be heard. But now the statute reads that the advocates have a deadline of 15 days within which to file their recommendation in relation to a report of investigation. We usually have 11 to 15 complaints scheduled for probable cause consideration at each meeting. So the advocates not only have to review the complaint, the order to investigate, the same materials that you do, then they have to analyze and write their advocate's recommendation and review it. But in addition to that, they schedule and prepare public hearings on cases with the Division of Administrative Hearings. That includes discovery, conducting depositions. They also negotiate settlements and do a variety of other things. Significantly, the advocate does not know when they will receive a report of investigation. They only know it when we put it in the portal and tell them it's there. They don't know, as you've seen, an investigative report can be a couple of pages. An investigative report can have 30 pages of narrative and hundreds of pages of attachments. And so they've, in a sense, lost their ability to manage their workload and their caseload and work efficiently and continue to work cases that are past probable cause. Also, I learned that the Office of Attorney General has a policy to have co-counsel on hearings. So even when we have a full ethics practice area of 2 attorneys over there, when they have a hearing, both of those attorneys are pulled on that. Having 3 attorneys in the ethics practice area aligns with the AG's policy, and it will make the review and prosecutorial side of the ethics docket more efficient and effective. Having that additional support person will also bolster those efforts. And I just want to take this opportunity to note, I know you have seen Melody has been our only advocate for a little bit of time. You see her stack of cases over there. I don't know where she hides her Wonder Woman or Superwoman cape, but it's a lot of work. And, you know, goes without saying, I hope that people get to take time off here and there over at the Office of Attorney General, but with things due every 15 days. So you can tell I support this, and I'd spoken with the Office of the Attorney General about it. Essentially, they are converting some positions, moving vacant positions into the ethics practice area. We don't have anything like that to use. We'd need $170,882 for their salary and benefits to add in that contract for the 2 positions. An additional $14,000 that the AG's office has identified in non-recurring funds for the contract for 26-27. I think the actual amount will end up for 26-27 being a little less because we're already a couple of months into this fiscal year and they'll have to advertise for the positions. If you agree that adding these 2 positions is not only helpful but necessary, I would ask today that you approve and support me in seeking a budget amendment, asking the House and Senate to allow us to use our carry forward dollars in fiscal year 26-27 to cover the required amount for the contract when these positions are filled, and that should the House and Senate approve that, that you also authorize me to sign an addendum to the contract to add those positions to the agreement and also make the necessary expenditure when those quarterly invoices come in. And I'm happy to answer any questions that you might have.
Are there any questions from the commissioners?
Mr. Chair?
Yes.
I intend to support our executive director in this ask. I just want to point out also that the Department of Legal Affairs Office of the Attorney General, not has just identified the availability, but has identified the need. Like that ask, it's not just coming from us, that's coming from them. And yeah, I was going to comment as well, Ms. Hadley, like it's a big step, and we are at a single point of failure right now, I would see in this. So I mean, I'm not a lawyer, but I could see, I think it makes a lot of sense. I was going to ask, like, if those spots do go unfilled, does contractually, and so question for staff, like, do those funds disappear, or do they only get used once those positions get filled?
Through the chair, the Office of Attorney General bills us quarterly for the amounts that they expend. So we don't just pay out the money if the money isn't utilized because the staff has vacancies.
Okay.
So, but in my 27-28 budget request that I'll present to you, in the event that you approve, that you agree today, this will be a part of my 27-28 request. I just don't have it currently in our existing operating budget, but we do have sufficient carry forward dollars to cover it, should the House and Senate agree to allow us to use them.
Thank you, Commissioner Rogers. Thank you, Executive Director Stillman. I echo Advocate Hadley works tirelessly, and we see the amount of effort, especially with Advocate Burns switching to a new job has taken over his cases and the work that he had done on those and working them up and then getting up to speed to present them to us. So we thank you for all that extra effort in covering that transition. At this time, I'll recognize a motion to adopt the request for additional advocate staffing for 2026-2027. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor?
All right.
All those opposed? The ayes have it. Moving on to another housekeeping matter, consideration of proposed 2027 meeting schedule. Next item for consideration is our 2027 meeting schedule. Executive Director Stillman, you are recognized.
Thank you, Mr. Chair. I think at the last meeting, we were just, Commissioner Rogers was going to check his military duty schedule to make sure he didn't have anything that conflicted. And he almost immediately that afternoon let me know. As far as I know, it's still the case that everything's clear and you don't have any requests to change the schedule as presented.
Mr. Chair?
Yes.
Yep, yeah, thank you for your, just holding one more time, on that. The schedule lines up perfectly. I'll be able to make all meetings. Not that you have to hold that because of me, but I do appreciate that.
Thank
So
you.
We just need a vote adopting the meeting schedule.
Is there a motion to adopt the proposed meeting schedule as presented in item 10?
I so move.
Is there a second?
Second.
All those in favor?
Aye.
All those opposed? The ayes have it. Item number 11, pursuant to statute, the term of a commission chair is 1 year. So it'll be time for me to pass the gavel on to the new chair, beginning at the next meeting, after orders are rendered next week. As such, the next order of business today is the selection of a new chair and vice chair. First, we'll entertain a nomination for chair. I don't know if it's tradition, but Chairman Fuste did this last year. I have a nomination for chair. Commissioner Rogers, I'd like to nominate as chair. Commissioner Rogers came onto the commission same time as me. He's been an active participant in all commission meetings. I don't even think you've missed one meeting. And is very thorough in his preparations, and I think would do a phenomenal job as chair. Are there any other nominations? Seeing none, I will entertain a motion for the election of Commissioner Rogers as our next chair.
I so move.
So we got a motion by Commissioner Oglesby, second by Commissioner Kerner. All those in favor, say aye.
Aye.
All those opposed?
You can't vote.
You can vote for, I guess.
You can vote for yourself.
Okay,
You
yeah, I
can.
think we actually
Yeah.
took that as a case.
We actually dealt with that before, yes. And the
He
ayes
still
have-
doesn't get paid for that.
Yeah. The ayes have it, and our next chair will be Commissioner Rogers.
Congratulations.
Is there a nomination for vice chair?
Chair,
Yes.
I'd like to nominate John Phillipson for the vice chair.
You
It's
test-
allowed.
It's allowed?
Yep.
Testing the limits of the home front here, guys. It would be my honor to serve along Commissioner Rogers as chair. I accept the nomination. Are there any other nominations for vice chair? I'm gonna have you do this one.
All right. All right, we'll entertain a motion to have Mr. Phillipson be our vice chair.
So moved.
We have a second.
Yep, second, and
Yeah.
I appreciate your continued service. And obviously, this is my first meeting, but to have someone with that experience carrying over, I appreciate it on behalf of the group, and I'm sure everyone else does as well.
Thank you.
All those in favor?
Aye.
Any opposed? All right, motion carries.
All right, moving on, we'll go to the reports. Chair's report. This is my last chair report. It's been an honor and privilege serving as a chair this past year, working with fellow commissioners, and particularly with the staff. The many hours spent on the phone with Mr. Zukowski and Executive Director Stillman. They are tireless workers for this agency. They do not punch a clock. They are constantly accessible, constantly working on issues 24/7. There's been many after 5 o'clock calls, some weekend calls. They're very thorough in their advocacy, and the amount of work and effort that our staff goes into, from Ms. Fulford, Ms. Westbury, to our investigators, our call center, our advocates, our legal team. Appreciate all the work that you do. It's what makes this agency run and fulfills its mission that was set forth in the Constitution. And thank you for all your efforts. They do not go unrecognized. So I will turn over to our Executive Director for her report.
Thank you, Mr. Chair, and thank you for those remarks. It's been a joy working with you this last year, and it's always fun to move on to our new chair and forge that that relationship as well. We're always very careful to make sure we're informing the chair of anything significant that they need to be aware of, and in preparation for the meeting, making sure that we're following all the laws and rules and moving things along as you all would expect. So thank you for that. And moving into the e-filing report, we have a few days to go before 11:59 p.m. Eastern Time on Tuesday, September 1st, which will be the very last minute for people to file their annual Form 1 and Form 6. Currently, local Form 1 filers are at 97% compliance. State Form 1 filers are a little over 98%. Non-judicial Form 6 are at about 97%. That was yesterday afternoon. I did not have a chance to check this morning. So overall, we're at 97.39% as of yesterday afternoon. We're trending a little bit ahead of last year. So I'm hopeful that in that last push of folks who have procrastinated and waited till that deadline, that they'll be busy this weekend. And we'll be very busy on Monday with calls, Monday and Tuesday. Speaking of calls, last week, I'm very appreciative to Keith and Lynn placing reminder calls to Form 6 officials whose forms had not yet been received. I also made some of those calls, and filers are always appreciative of the reminder. And so we look forward to them complying. The call center today is their last day at work for the commission for this endeavor. They've received over 4,000 incoming calls this season. They've made outgoing calls to contact 1,687 of our Form 1 individuals who had not yet filed. And they indicated to me yesterday that about 785 of those individuals that they reached to file their forms did so while they were on a call. So again, that grace period expires September 1st. After that, it's $25 a day for each day late, capped at $1,500. So hopefully we can get that compliance up to the range of about 99%. Always hopeful for 100%, but we'll be happy with 99. Very much want to appreciate the work of our support team, even though we have a call center. Commission staff works very, very hard during disclosure season with additional work, and also our disclosure team, Kim, Emily, and Kiana, who work in the back corner of our office tirelessly. You don't see them get up very much and stick their head out. So thanks to everyone for their efforts this season.
Thank you, everyone. At this time, I'll entertain a motion to adjourn our public session.
So move.
Second.
All those in favor?
All right.
Ayes have it. The public session is adjourned. We'll resume in